Hey everybody, it's Paul Yokobitis from Cary Estate Planning, back with another long form Q&A episode addressing numerous questions. Today's are about living trusts, revocable trusts, family trusts. They're all synonyms for each other, but same topic. What are they? How do they work? So we will start with, do you need a lawyer to make a living trust? The answer literally is no. You could create your own living trust. There are probably templates you could find online. You could probably write one yourself. Would I recommend it? No. This is even more so than wills, because trusts end up being potentially a very long and drawn out and more complex administration than just a will. The other aspect is, how do we title, right? So trying to figure all this out on your own ends up being very risky, because you only know so much. You don't know what you don't know. And so creating your own living trust without the strategy to implement it, without understanding its purpose and how it works, can be very risky. So can you create one without a lawyer? Yes. Should you? No. Next question is, how long can a living revocable trust be kept open after the death of the trustee? I wonder if they actually meant trustee. Generally speaking, a revocable trust can stay open for a very long time. It just depends on how it's structured, who it benefits, and how and when, and those sort of things. Whether it includes powers of appointment, whether it includes sort of dynasty provisions, really depends on the intention of the trust. Also, the age and longevity of the beneficiaries. The trustee is the person who's appointed to administer the trust. There are usually going to be provisions within a trust that the trust will not just terminate because the trustee's passed. There's usually going to be successors, alternates appointed. And in the absence of one, usually beneficiaries can appoint a successor or alternate, or a court, a judge with competent jurisdiction can appoint a trustee as well. So generally, there's not, significant restrictions on how long a trust can stay open. Now, it could be that trusts then sort of cascade into subtrusts or split or vest different interests at different times. That's a lot more nuanced of a question, but generally speaking, a trust can live for a very long time. Are there any valid reasons for not putting a house you own into a living revocable trust? It really depends on how you own it outside of the trust first. So some states, North Carolina is not one of them, but some states have a unique ownership for married spouses that is terminated by putting a house into a trust. That's called tenants by the entireties. And North Carolina basically allows that tenants by the entireties to be maintained in the trust. Some states, putting the house in trust severs the tenancy by the entireties. The entireties asset is sort of a liability protection against claims of an individual spouse, creditor claims, judgments, those sort of things. And so that's a pretty important protection in the event that, only one spouse gets in financial or legal trouble. It can protect the marital home from being attached to or leaned against by the creditor. If the state that you live in, and again, this isn't the case in North Carolina, if the state that you live in basically severs or terminates the entirety's ownership by placing that house in the trust, then that's a good reason not to put it in the trust. There can also be, other valid reasons. That's probably the most common or most important. You could also have it in some other ownership capacity that you don't want controlled by the terms of the trust. Like it could be owned with rights of survivorship to a co-owner that's not your spouse, like another family member, maybe a parent. Then you wouldn't want to put a house in the trust, or your ownership interest in the house in the trust. Next question is, I want to add money to a living trust. Do I just deposit the money to its bank account? Do I keep a record of it? How? So titling always controls. So the trust controls what is owned by it or titled in the name of the trust. And to be more specific, it's the trustee's name, because trusts don't actually own anything. Their trustee does. So if you want money to be added to a trust's ownership or be governed by a trust, you have to place it in an account that is titled in the name of the trustee of the trust. So if it's the John Smith Living Trust, you would want the account to say John Smith, trustee of the John Smith Living Trust. And you would put the money into that account. That is a trust account, right? That's how you would add, liquid assets to a trust. You generally would have statements produced to that effect, right? Deposits being made, withdrawals being made. That would basically evidence that the money is there, as far as what the record would be as of ownership, sort of the titling controls. Next question is, if a will mentions a trust that was never set up, is the will valid? Depends on how you mean, right? So sometimes a will creates a trust. So if the trust was not created prior to death, it could be created in the will. That's called a testamentary trust. Sometimes we see directives to that effect for minors, that an interest passing to a beneficiary under a certain age, or it's 18 or 21 or some other age, that the executor is to create a testamentary trust and hold the assets for their benefit. That trust doesn't exist until death. That's what's called a testamentary trust. It is a post-death creation. And so if that's the case, then yeah, it's totally valid. If it names a living trust that does not exist, then that may be a void gift, may be an invalid transfer. And so then you would have default provisions to the, otherwise, right? Who are the remaining beneficiaries? If there are none, then it would likely fall to intestacy, which is not an ideal outcome. Let's see. Next question is, does a revocable trust protect assets from divorce? No, not while it is revocable. But after it becomes irrevocable, it can, as to the beneficiary. So if parents, for instance, set up a revocable trust that they fund at their own death that holds assets for a beneficiary, maybe their child, once they pass away, that trust becomes irrevocable. Once the trust is irrevocable, if the child gets divorced, then the assets are totally protected as long as they're still in the trust from any divorce claim and any other creditor claim, right? It's sort of the upside of an irrevocable trust. But while the trust is revocable, it provides zero creditor protection for anybody involved, most specifically the creators of the trust. Next question is, why would someone create an irrevocable trust as opposed to a revocable trust? There are a lot of different reasons, and usually they come in one of three varieties. First is going to be creditor protection. So if you wanted to create sort of a shield or a wall around certain assets from being claimed by or attached to by creditor claims during your lifetime, you would have to do that through things like irrevocable trusts or through like corporate structures like LLCs or corporations, where essentially you're divesting yourself of ownership. So if you get in trouble, assets that are not yours can't be attached to, right? Another reason would be for Medicaid reasons. Could be either Medicaid eligibility, Medicaid enforcement, basically trying to divest yourself of assets so that assets don't count against you for purposes of qualifying for Medicaid, or so that Medicaid doesn't attach to them after you're gone. And then the third is usually a tax reason, right? That you want to take advantage of, your gift exemption, or make sure that growth of an asset happens outside of your taxable estate. Those are usually the three sort of camps of reasons that somebody would set up an irrevocable trust. And that's because a revocable trust doesn't provide any of those protections or those benefits. It's treated as if you still own it. Next question is, should your term life policy be placed in your revocable trust? That depends. Probably not. Payable to, maybe, depending on what you want to happen to that money. So the difference would be, we're not assigning it to the trustee of the trust. We would be designating the trust on the beneficiary designation to make sure that the death proceeds of the policy, the actual cash value, is paid to the trust when it's received, so that the trust terms will govern the administration of that value. Next question is, do revocable trusts become irrevocable upon the death of the grantor? Yes. And that's by operation of law. Usually, governed by the terms of the trust itself, but that's by operation of law. The only person who can revoke a revocable trust is its creator, which is called the grantor. Once the grantor has passed, no one then has the legal authority to revoke the trust, because none of the creators are still alive. That's why it becomes irrevocable. Next question is, can you sell land out of a revocable trust? And the answer is yes. While you're alive, if you are the creator of the revocable trust, it's pretty common for people to move real estate into the name of the trust so that it avoids any sort of court or creditor attachment after they're gone. But during your lifetime, the law treats that property as it's still being yours, because you can revoke it, you can withdraw it, you can terminate the trust whenever you want. And so likewise, you can sell any of the property that's in the trust during your lifetime. And that's pretty common. People will move, downsize, relocate entirely, right? Whatever the reason, a revocable trust is amenable to that. So you as the creator can do that. Absolutely. Next one, does a lawyer have to change your revocable trust, or can you do it on your own? Either. The process of amending a trust is, or can be, complicated depending on the nature of the amendment. But it's not something that is absolutely mandatory that a lawyer does. If you have the ability to, restate the formalities of the trust, execute it properly, that it be signed, dated, and notarized, and recite and revise the portion that needs to be amended, then that's something that you could do on your own. It may be difficult though, because you don't really know how to do it, right? You could probably tackle it yourself if you did some research, but it's sort of, the risk incumbent in that is pretty significant. All right, that's it for today's questions.